correct, and we really appreciate being here with us. I'm really excited to bring up our friend and person who's in charge of Knobee Martens here in Austin, Eric Furman. There he is. Eric, welcome.
Yes, thank you, Mark. Good morning and welcome to the virtual legal track for Austin Startup Week, sponsored by Knobee Martens. My name is Eric Furman and I'm a senior partner at Knobee Martens, and it's my pleasure to present our 3-session series on intellectual property protection for early stage companies. Knobee Martens is an intellectual property law firm, and we specialize in intellectual property. It is our focus. And we have more than 250 attorneys in 7 offices throughout the United States. Our focus is only intellectual property, unlike general practice firms that have several practice areas. We only work in the intellectual property space. We not only obtain and enforce patents and trademarks for our clients, but we develop IP programs that attract collaboration and investment. We work with our clients located throughout the world and have several clients here in Texas and in Austin. We have a global practice, and whether you're obtaining IP protection or seeking to enforce your IP rights, we provide several paths for our clients to secure IP protection in the U.S. and abroad. One of our goals is to collaborate in a meaningful way with our clients. We seek to learn the business and business goals of our clients' companies so that we can better structure an IP strategy that will achieve the company's goals in a cost-efficient manner. We have a strong technical expertise in a variety of fields. 95% of our attorneys have technical degrees, and many attorneys have advanced degrees and industry experience. We are very pleased to have been recognized by our clients and peers to be one of the best IP firms in the United States. We are proud to have once again achieved the ranking of a first-tier IP firm in patent and trademark prosecution, licensing, and litigation. We're a full-service intellectual property law firm, and we counsel our clients in all areas of patents, trademarks, brand protection, copyrights, and data privacy, litigation matters, as well as patent administrative proceedings, and we help develop an IP strategy for our clients that achieves the company's goals. Today, we're pleased to bring a program that has 3 sessions. The first session is What Do I Need to Know? Recognizing common IP issues faced by startup companies. We'll then have a short networking period. And then in our second session, we'll describe how to position IP for investors and exits. I'm very pleased that in this second session, we'll be presenting 3 of our clients. We have Rose Thiessen, who is going to be joining us, as well as Jeffrey Thatcher, and also Troy Hartzell is going to be joining us. Rose is a general counsel at Epitracker, LLC, and founder of SynEffects. And Jeffrey Thatcher is chief scientist and principal investigator of Spectral MD. And Troy Hartzell is managing partner of Evolution Capital Advisors. Our third session, entitled Ask an IP Attorney Specialist, Insights and Experiences, is a series of 4 breakout rooms moderated by partners in our firm that specialize in the areas of software, information, and electronics. Medical devices and life sciences is a second breakout room. Medical and energy and is the third, and IP essentials, branding, trade secret enforcement is a fourth. This is an opportunity to meet our attorneys that are specialists in each of these fields and ask any questions that you may have. So let us kick off the event with our first session, What Do I Need to Know? Recognizing Common IP Issues Faced by Startup Companies. Thank you for joining us.
Well, hi, everyone. So we're going to start promptly at 9:15. So we've got a few minutes to take a break, get some coffee, get relaxed, get settled, because we've got a powerhouse panel coming up, and we'll see you at 9:15. Thank you. Hi, everyone. Thanks for joining us for our very first session of the IP track for Austin Startup Week. We have a powerhouse panel, as I mentioned, of Knobee, Martens attorneys talking about some really sticky IP issues. And the title of the track is, What Do I Need to Know? Recognizing Common IP Issues Faced by Startup Companies. And so here are the things we're going to talk about: employment agreements, contract employees, gig economy employees, open source software, third-party software, patent portfolio work, copyright and trademark work, obviously, trade secrets and confidential information and how is that managed, data rights, data privacy, and IP risk assessment and management. Now, that all sounds really, really, really complicated, but this team is going to bring it right down to our level, and we're going to get a lot out of it. So with that, I thank you very much for being here, and we'll kick it off now. Thank you.
Okay, hello. I think we are going to get started in a bit. Thank you, Mark, for that introduction. And as Mark mentioned, we have a list of topics on this IP track to cover for you. Throughout the day today, you'll be hearing from some of our colleagues and some of our clients, and hear more about a lot of the issues that Mark mentioned. So let me start with our panel, and then we'll go into what we're going to be discussing. So the panel today, I'm Jessica Axum. I am a partner. I'm located here in Texas, and I focus mainly on medical device and biotechnology. And I did my undergrad and law degree here at the University of Texas in Austin. Another panelist with me today is Sabing Lee. He is based out of Orange County office and is a partner in that office. And his background is in medical devices and materials engineering. And our third panelist today is Paul Stellman. Paul has a background in electronics, energy, and semiconductors, and that's where his practice is mainly focused. And he was based here in the Austin area, and he attended some other school in Texas that we don't have to talk about. Okay, so we'll go on to the topics we're going to talk about today. As I mentioned, there will be plenty of conversation here, and then hopefully in our prior sessions. Feel free to post any questions you have in the chat. We will be monitoring that as we go along, and hopefully we can get to all of your questions. If we can't, we will all be in the breakout sessions later today, which are titled Ask an IP Expert. So any questions you have, or if you want to talk more one-on-one, please join us for those sessions. There will be several with us and our colleagues from Knobee as well. So Paul, would you like to get us started with the first question here?
Sure. Thanks, Jessica. You couldn't resist getting a dig in on the Aggies. We'll see how you guys do when you finally join the SEC. Good luck with that. So I'm going to start with, we have all these IP issues with you. I figure I would just give you examples of the types of IP that you can use to protect your company before my co-panelists get into these specific issues. So 4 types of intellectual property. There's patents, trademarks, copyrights, trade secrets. If your company is developing any new process, a new machine, some new electronic gadget, an article of manufacture, or some new substance, some new composition of matter, then you might consider filing a patent application once it goes through the process, which we'll talk about here a little later. If it's granted as an issued patent, then you have the right to exclude others from making, selling, using, or importing that new and useful product. The second type of IP, trademarks. Trademarks really gets at the heart of your brand. It includes words, logos, symbols, even color patterns and sounds that indicate the source of the goods. Trademarks give you the right to prevent the use of marks by others that are likely to confuse consumers, and they can greatly enhance your marketing strategy. So the Starbucks coffee logo, everyone knows that and can see that, from the interstate, 2 miles away. You may not be able to read Starbucks coffee, but you can tell that, oh, hey, there's a Starbucks coming up in a couple minutes. Third type is copyrights. Copyrights, if your company has developed any original works of authorship, if you have any books, any technical manuals, musical works, sound recordings, videos, for example, even source code for those that work in software space. Even this presentation, you'll see at the bottom is a copyright. Once we put this in the presentation and saved it, it becomes copyrighted. Copyrights on these works give you the right to prevent unauthorized copying or distribution of those works. Then finally, trade secrets, the fourth type of intellectual property. These protects valuable company information that is not generally known to the public. So for example, if your company has some proprietary processes or methods, materials, devices, patterns, schematic, anything that has value to the business as business information and is not known publicly, as long as you maintain certain procedures to keep that confidential, then you can get trade secret protection. And trade secrets, you'll see, prevent unauthorized use of your trade secrets by others. One way to think about intellectual property is that it's really the creation of different things. It relates to the creation of ideas, the creation of works of expression, the creation of brands. So for the first idea on the left here, you see ideas. So when you create an idea, you can either file a patent application or you can keep it as a trade secret. The next point we'll talk about, the next question for the panel, if you will be about whether your company should file a patent or whether they should keep it as a trade secret. There's a lot of issues we'll get into with that. But for now, you see on the left side, you got an example of a utility patent for some smart home device, where your phone is connected to your TV and your toaster and your toilet and whatever. That's a good example of something you may want to file a utility patent for. On the right, trade secrets. If you choose to maintain information as a trade secret, a good example of that is WD-40. So everyone knows that the WD-40 lubricant, which you use to pretty much prevent anything in your house from squeaking or making noise. That company's been around for almost 70 years, since the early 50s, and they've never filed a patent application on their composition or the method for making it. Instead, as you'll see in the next section, they've kept it a highly confidential secret. They've used procedures to keep it secret, so no one knows their magic sauce, if you will. They can't exactly reproduce their lubricant. And I think another interesting point about WD-40, this is really kind of a combination of where they have a trade secret. They're keeping their secret sauce confidential, and that gives their business value because that WD-40 has high quality, but it's also their branding because they have trademarks to the name WD-40 and probably to the look of this bottle, and they're associating the high quality of their recipe with their company name. And so that's kind of how you get synergies between these different types of IP. The second way you can create intellectual property is you create some expressive work. For example, you see design patents is one way you can go to protect expressive works. If you have some product that has a unique look and feel to it, some ornamental design, then you can file for a design patent to exclude others from making or using it. You see here, obviously, Apple had filed for a design patent to cover an earlier version of the iPhone. It's got distinct a look to it, the rounded corners. It's got the home button at the bottom center of the screen. And so if you have some similar product or article, you can try to protect the look and feel of that by filing a design patent. Another way to protect expression is through copyright, whether that's a source code or work of some sort of book or manual. You don't have to file for a copyright. A copyright comes into existence when you put that in some tangible medium. So when you type up the source code and it's saved, when we typed up this presentation, it's saved, it gives you a copyright on it. And if it's an employee of your company that makes this, then it becomes the property of the company. Now, some issues to look for in copyrights that you should talk to your attorneys about is ownership. That's a big issue in copyrights, especially if you're using third-party developers for your software or other works. It's important to make sure that you have the rights and agreements in place because ownership can get a little tricky when you're dealing with third parties. And I know Sabine will touch generally on IP ownership in the next part of it. And then finally, the IP protects creation of brands. So, Botox is a famous word and logo, Starbucks, of course. We highly recommend that you register your trademarks with the U.S. Patent and Trademark Office. You come up with some name and use it in business without filing for registration, but that really provides you limited rights. Filing and registering it with the U.S. Patent and Trademark Office gives you nationwide rights for the mark once it's registered. It also makes it a lot easier to enforce if people are using a confusingly similar mark. You don't have to show that you are entitled to it. And after a number of years, 5 years, the mark becomes incontestable. So a lot of reasons we would recommend for registering those marks. So I think that covers the 4 different types of intellectual property. And the next topic, we'll get to this choice of whether you file for patents or keep a trade secret. So we get this a lot from clients. Should we file for patent protection for my idea or just keep it as a trade secret? A few issues to look at. First of all, patents, you have to prepare an application and submit it to a government agency. In the US, it's the US Patent and Trademark Office, the European Patent Office. It goes through a process and hopefully it issues out a patent. When it issues as a patent, that gives you rights for 20 years from the earliest filing date to exclude others from making, using, or selling. So the benefit of patents is you get a 20-year limited monopoly to exclude others from using or selling your idea. But the bargain for that is that you must fully disclose, explain how your inventive techniques work, explain how you make them. That's sort of the bargain that you get for getting the 20-year limited monopoly. So, and that will eventually become public. So your invention will become public in exchange for that 20-year limited monopoly. Patents are good, regardless of whether someone just copies your idea or whether they independently develop it. If they live across the country and they've never heard of you and they develop it independently, you can use your patents to exclude them from practicing your invention. By contrast, trade secrets have a different value proposition. Because of their secrecy, they provide an economic advantage because they're not generally known to the public. WD-40, as I noted above, for 70 years, they've been able to keep their secret sauce secret, and they haven't, competitors haven't figured out exactly how to reverse engineer it. But you have to make reasonable efforts to maintain secrecy. You see in this image here, the CEO of WD-40, they take it very seriously. Apparently, they keep their recipe in a vault in San Diego banks, and I guess they're moving banks for whatever reason. And so they put the recipe in this briefcase here, handcuffed it to the CEO, hired Brink security guards with trucks to go across town to the new bank, which you see there. Now, we may not recommend that kind of precautions. We don't, it's not necessarily going to recommend you hire Brinks and use handcuffs and all that, but you do need to talk to your attorneys about what precautions, what procedures you need in place to make sure that it's confidential. Trade secrets is relatively inexpensive, and a benefit of them is that they last as long as that information is maintained confidential. So again, WD-40 been around 70 years. They've been able to keep those trade secret rights for that long time. But the problem with trade secrets is that you can't stop independent derivation. If someone comes up on their own with the formula, you can't stop them from using it. It only prevents someone from misappropriating your trade secrets. So I hope that help give you an idea of when to choose patent protections or go the trade secret route. For the next topic, I'll turn it over to Sabing, who's going to talk about IP ownership.
Thanks, Paul. I actually wanted to make a point on the trade secrets because one thing that I've seen a lot recently is on data protection. And so I've seen this with some of my clients who maybe have a very data-based business and they need to think about whether their data is something that they need to maintain as trade secret. So I have a client now who kind of realized a bit late that their data that they were accumulating over time, they were a service provider, but they were accumulating a lot of data. I think they did a reasonable job maintaining secrecy, but they realized over time that the data was really, really valuable. And they started to think more about, well, we really need to clamp it down. We need to make sure we have the right agreements in place. We need to make sure that confidentiality is preserved. And so this obviously overlaps with the topic I'm going to talk about, which is IP ownership. But I think it's also very important to think about your data to make sure that you own your data and that you keep it confidential. So I think that's an important point.
Thanks for the feedback, Saving. That's a good point.
Okay, so let me transition to ownership because this is obviously one of the most important aspects of intellectual property. You need to make sure that you own your IP. This applies to patents, trademarks, copyrights, data, everything that Paul talked about. The example I'm going to give is primarily in the context of patents. And so we'll take this toaster as an example. And so imagine that you're an early stage company. Maybe you haven't even formed your LLC or your C Corp yet, but you have an idea for a toaster. But maybe you and a friend co-invent the toaster. Absent any agreement between the two of you or anybody else, the patent that would be filed on the toaster would be jointly owned by the two of you as the inventors. So the presumption is that the inventors own the invention and therefore own the patent. Now, one qualification on that is that each individual who contributes to this toaster has to make an inventive contribution. So for example, let's say Paul comes up with the idea of the toaster. He draws up all the schematics. He figures out all the details. And then he says to Jessica, here are all my schematics. I want you to make me the toaster. And all she does is she takes her normal engineering knowledge, which she has a great bit of, but she just takes the standard knowledge that somebody would have and builds the toaster. In that situation, Paul would only be the inventor. But let's say Jessica adds some invention to the toaster. So maybe Paul has the basic idea for the toaster, and Jessica says, it'd be great to add some electronics to this toaster. Let's make it a smart toaster. And she adds some additional feature. And you see this a lot when you're dealing with outsiders. So you have a great idea, you share it with somebody, and then they think of something that can improve upon it. Once Jessica does that, she potentially, or she would become an inventor of the ultimate patent if her contribution is described in the patent. And so the basic point there is that Paul and Jessica really should have an agreement as to who owns the invention. And of course, with a startup company, the typical situation is that there's a company involved. Maybe Paul is the CEO and the founder of the company, and he hires Jessica as an employee or as a consultant. And then she would sign a document saying that I agree to assign my rights. I hereby assign all of my rights in any invention that I make to Paul's company. That would be the ideal situation. But what we see dealing with early stage companies is that oftentimes that is not the case. Early stage companies deal with a lot of outsiders, and not always are the agreements put into place. So yeah, you can go ahead and go to the next slide. And so these are some of the ownership problem areas that we encounter typically in our practice. So first of all, you might have an individual that you want to hire who has a prior employer. You might find somebody that you want to hire, and it's because Jessica has all of this great toaster making experience from working at, I don't know, KitchenAid, whoever makes toasters these days. And so she brings that knowledge over, but does she have any obligations still to her prior employer such that she cannot assign her rights to Paul's company? Maybe Jessica works at a university, Toaster University, and she's done a lot of research there. We find issues just with universities because I deal in the medical business, so I deal with a lot of doctors and surgeons who are university affiliated. And so they have obligations. And so when your startup company is looking for investment or acquisition later, these are things that an investor or acquirer will look at to see if does the main inventor of this invention have a prior obligation, and therefore your company doesn't really own what they think they should own. I'm going to give an example in a few slides on non-disclosure agreements, but one problem we often see is that companies think that all they need early on is a non-disclosure agreement, and what they don't realize is that the NDA doesn't have all the provisions that they think it should have, or they just don't think about these things. Many NDAs do not have an assignment provision. NDAs are typically just don't disclose whatever I'm showing to you. And so this is something that we'll talk about as a potential issue. We find these days, especially when you hire consultants or contractors, they often subcontract to others. So Jessica and I were dealing with a situation recently where our client hired a company to do the software for its medical device. And when we went to get the assignments and we asked who were the authors for the artwork, as well as the inventors for the patents, they said, well, we actually hired all of these other companies and other individuals. And so then we had to go through and check, did the contractor that we hired, did they have proper assignments with their consultants? Most of the time they did, but Jessica and I have one case right now where one guy didn't sign and he's refusing to sign at this point. And those are the types of things that we could have, or our client really could have tried to figure out before they even hired these people. Typically your agreements should say something like that, but oftentimes your contractors might sign something not really thinking about what they're signing. So you really do need to make sure of that. Another problem area is joint development agreements, because if you're jointly developing something with another company, you need to figure out who's going to own the IP out of that joint development. Our preference is that you pick a side to own, because there are problems when you have joint or co-ownership between two parties. It just becomes very complex. Acquirers don't like it. It's actually better in my mind that you pick a side to own it, and then you have a license back to the other side. Licenses are a little bit more predictable, and you can carve out with a license what rights each side should have. So that's my preference, but obviously talk to your attorney about that. We often see work performed without any sort of formal agreement, and this might arise most often with a purchase order. So maybe you're working with a vendor or a supplier, and so you might have a purchase order with some standard terms and conditions, because you're thinking that the vendor is not really supposed to invent anything. All they're doing is supplying you some part. But again, maybe they come up with some improvement. And so your standard terms and conditions may or may not have an IP assignment provision. So I think that's something to just be mindful of when you're working with a vendor. And then the last point here is that, when a company has licenses, and so this could be a license in or a license out, it doesn't matter. Just be aware of what the license says. It's not necessarily a problem area. We see licenses all the time, but you need to know the scope of your license. You need to know what field you're limited to, or if you're licensing out, what rights does the other side have. You need to make sure that your license doesn't provide some restriction on the assignability of the license, so that if your company is acquired, the license would pass on to the acquirer. It doesn't just terminate. And so that's just a problem area, or an area to be aware of, just in terms of when you're looking at the overall ownership picture.
So Saving, I had a question for you. I know whenever I'm doing defending a due diligence for an investment round or something like that, when investors are looking at the company, if there's a major problem in that diligence, like at least for me, 80 to 90% of the time, it's some ownership issue. How does that compare to your experience where there are problems in due diligence?
I find in my diligence experience that most companies come to me and say, we don't have any ownership problems. So don't even bother spending time on that. And then maybe not 50%, but there's a good chunk of the time that there is some ownership issue. Some prior inventor who has some rights, somebody who thinks they contributed something, or some license issue. So it's never perfectly clean. But I will say that the most common issue, which is the one that Jessica will cover later, is typically freedom to operate. And so whether a company is infringing somebody else's IP, but certainly don't overlook ownership. Ownership is one of the first things that any company should look at. Okay, so I want to talk a little bit more about what agreements do you need to protect your rights, but I'm going to start off with an example here from a case study. And so this was a client of mine, a company called Cartier Q. And what they were doing was that they had developed a transcatheter mitral valve. And so this is a picture of what that would look like. What they had developed and had prototyped themselves was the metal frame that the valve itself, the prosthetic valve, would go inside of. They hired a company called Neovasc to put the tissue valve into the metal frame. And so this was a vendor that Cartier Q hired to essentially build its prototypes, put the metal frame with the tissue valve together. If you go to the next slide, this is a timeline generally of how Cartier Q and Neovasc work together. So it starts with an NDA, as is typical. So they met at a conference, said, oh, it'd be great to work together. Let's talk and see if there's any potential for collaboration. So both sides said, oh, we should get an NDA. Cartier Q actually received Neovasc's NDA, didn't have the attorneys look at it, and signed the NDA. It was pretty straightforward. I'll tell you that there were no further agreements really signed between Cartier Q and Neovasc. So under the NDA, they talked, they decided to work together, and then Neovasc proceeded to make prototypes for Cartier Q. And so over a period of about a year, 9 months or so, Neovasc was making prototypes for Cartier Q while under this NDA. What Neovasc didn't tell Cartier Q is that they were also working on its own program for a competing mitral valve. And so you can see the NDA was signed in June of 2009. Neovasc began its own project called Tiara that began in October of 2009. And then they were developing its own competing device, the same engineer working on the same technology, but the device looked different. So you can see in the top left, that was what Cartier Q's device looked like. Neovasc's device looks like what's on the bottom right. And you can think for yourself as to whether you think those look similar or not. And so after about 9 months, the relationship ended. What happened next is that Neovasc had filed for a patent application, but the patent application doesn't publish immediately. It publishes 18 months after the initial filing. And so Neovasc had filed a patent application in May of 2010. Cartier Q actually filed its patent application a little bit later. And then Neovasc's patent application publishes. And so that's when Cartier Q for the first time can see, oh, Neovasc is doing something that we don't think that they should be doing. And so we were representing Cartier Q thinking about, well, what should we do about this? This is a startup company. They were probably in Series A around the time of these activities. They had raised some Series B money so that by 2014, which is about when the statute of limitations runs out, Cartier Q actually did decide to file suit against Neovasc for breach of contract, breach of the NDA. and for trade secret misappropriation. Ultimately, in the history of CardiAQ, they were acquired by Edwards Life Sciences. And so this was a good thing for the litigation because once they were acquired, they were pretty well funded. The case ultimately went to a jury verdict, and Neovasc was found to misappropriate the trade secrets, breach the contract, and the jury awarded CardiAQ $70 million. So this stands for the principle that the NDA was obviously very useful here, that the company had an NDA. If you go to the next slide, Jessica.
Sorry, I had a question about that real quick. So how did you find the Neovasc patent when it published? Were you doing any kind of searching or monitoring?
The company was. So the founder of the company was using something called, I don't know if it's around anymore, it was like freepatents.com. And so he had just entered into the search terms, some standard terms like transcatheter mitral valve, and he saw the publication pop up. And as soon as he found it, he sent it over to us to take a look at. So the typical term in the NDA is that, well, let me first say that the use was limited to evaluating the proposed business relationship. So again, as I said before, there was no further agreement between the companies. You would normally expect some sort of consulting agreement to be reached between the companies. There really wasn't that. There were probably purchase orders, like I was mentioning, but there was nothing further than the NDA that we could really rely upon. But the NDA had the typical term that's helpful, which is that the use of the confidential information cannot be for its own benefit or for the benefit of any third party. So they cannot use this confidential information. Neovasc's story was that, well, even though I don't think they would disagree that they were competing, they would say that they were not using the confidential information because they had independent knowledge, or there was information that was already in the public domain that they were drawing upon. But what really hurt their case is that they were learning all about the design history, the filings, the engineering problems. And so even though CardiAQ was disclosing some of its own inventions in presentations and in patent filings, there was a lot of engineering know-how that goes into when you develop a product. And that was really the key to proving that Neovasc took advantage of receiving that information. And so that's what I ultimately think helped the jury decide that there was misappropriation here and the breach of the contract. But again, importantly, there are some things that we think that in retrospect, the company could have had in further contracts. So obviously the consulting agreement would have been nice, but even with the NDA, and you'll see this now, that there might be some sort of non-compete clause. So some agreement not to compete in the same field. There's probably some legal uncertainty as to how enforceable those provisions are. It depends state by state. My understanding is that Texas is actually more favorable to non-competes than some other states. So it doesn't hurt to include something like that, but talk to your lawyers. But at least a notice of co-development or notice of development that you might be working with somebody who is going to develop or has already been working on its own internal program, something like that. Some agreement to segregate employees. So here we had a situation where the same inventor, the same engineer was working on both projects. And so if you're working with a vendor, think about, well, if you've got something else going on in your vendor's program, maybe keep the employees separate. And then, as I mentioned, there was no assignment clause either. So the NDA did not have any assignment provision where if Neovasc invented something based on the confidential information of CardiAQ, Neovasc should assign those inventions over to CardiAQ. Now, what happened here, though, is because the inventions that Neovasc made were based on the confidential information of the CardiAQ inventors, we were actually able to establish in the litigation that CardiAQ should have co-ownership of the patents because, as I mentioned in the first point, the owners of a patent are based on the inventors. And so by establishing that what Neovasc was doing was in part invented by the CardiAQ inventors, ultimately the Neovasc patent that was filed is now co-owned by both Neovasc and by Edwards, who is the ultimate acquirer of CardiAQ. So here I just wanted to provide what I would consider a checklist of the types of agreements you should be thinking about. So obviously start with the employee agreements. So if you have employees, make sure that they've signed, it's pretty standard agreements, but make sure they have the good assignment clauses like we talked about. Similarly with the non-disclosure agreements, think about having the IP assignment clause in there as well. Data rights, obviously with respect to data, beyond the maintaining of confidentiality, have clear provisions as to who owns the data if your company relies on data. Consulting agreements, vendor agreements, manufacturing supply, all of these things, kind of the same point, just making sure you have these agreements. Think about who you're working with. I made the point on joint development agreements in terms of trying not to have co-ownership if possible. And then just look out for your purchase orders. Sometimes these purchase orders have just standard boilerplate terms, but there might be something further that you can add to those to make sure that whoever you're sending these over to will agree to the terms that you want.
And another point on that, agreements that I wanted to make was timing and the term of all these agreements. So I see a lot of clients come to us and they're like, oh, we have an NDA and a confidentiality agreement, but it expired 3 years ago and they didn't know that. They didn't read the term of the agreement and what the terms of that were. So, and we try to go back and backdate and say, oh, we have this period of time from when it expired to now. We want to make sure that's confidential information as well. But it's cleaner if you know the term, you're monitoring it, you know, when your confidentiality agreement is expiring, to make sure to get a new one in place, or a non-disclosure agreement. And this goes for any of the other agreements as well, joint development and manufacturing.
So I'll talk about now about how to build a robust patent portfolio, topic 5 here. So where to start with building your robust portfolio? You start with what's patentable. What exactly can you get a patent for? Section 101, which is the patent of the patent statute, tells you what you can get patents for. You can get patents for processes or methods. So, for example, if you're developing a new a process for making a product, or whether the product's old or new, if it's a new process, you can try to get a patent for it. If you're coming up with a new machine or gadget, some article of manufacture, some new composition of matter, that can qualify as patentable subject matter, and you may want to file a patent application. Of course, the Supreme Court has specified that some things in this list are not patentable under 101, specifically some software inventions. Now, some software inventions are okay under Section 101 and some are not. Similar, some biocompositions are patentable and some are not. We can go in a little bit more detail on that in the third session, the Ask an IP Specialist, if you have more particular questions about what exactly is patentable subject matter. Importantly, the patent only gives you the right to exclude. So as I noted above, patents do give you the right to exclude others from making, using, selling, offering to sell, or importing your inventive product. But there's an important question as to the scope of that right. Sure, you can exclude others, but what does that mean? How big is that right? And to that, you need to talk with your attorneys to make sure that the scope of your claims, which are sentences at the end of your patent, to make sure that those are broad enough to cover not only your product, but also potential design arounds, slight modifications to it. You want to be broad enough to cover those, but not overly broad so that it runs into the prior art. So that's an important qualifier for that right to exclude, is you need to know what the scope of that right is. Importantly, we have a common misconception when a client gets a patent, they say, yay, I can go release my product now. But Jessica's going to point out that that's not the case. It only gives you the right to exclude. It doesn't give you the right to actually sell your product, because a third party could have a patent that covers that. So now that I know that my company has some patentable subject matter, how do I identify inventions? How do I know which things to file a patent for? Well, first, does it solve some problem? Are you developing some product and you've run into a problem over days, weeks, months, and you come up with some fix for it that just makes everything a lot easier? Solving some problem is a good example of something where you want to file a patent application. If it improves a product or process, maybe you have a process, for example, that works pretty well at its objective, but you find some modification that increases the efficiency by 20, 30%. That's another good example of something you want to file a patent application for. If you have a new product, so let's say you have one product that you developed and filed a patent application for, back in 2015. If you come up with accessory products that are different from it, you may want to file a patent application. If you come up with just completely different product lines, you may want to file a patent application. But you also may want to patent new generations of your product. So let's say you make some improvements, from your 2015 product, you make those in 2021. It's similar product, but you add some bells and whistles, some new functionality. That also you may want to you should consider filing a patent for, because provided added benefits of extending your term. So your first patents you filed in 2015, they'll have a 20-year term to 2035. If you file on the improvements in 2021, those patents, if they issued, would have a term to 2041. So you can kind of stagger the terms of your patents by filing for next generation products that you create. And then finally, it doesn't have to be for your own product. If you see a competitor's product and you think of improvements to patent to that, then you can file a patent on those. Now, before actually going through the patent process, we generally recommend conducting some sort of patentability search, whether it's before or after you file your provisional application. Certainly before your non-provisional application, it can be good just to see what's out there so you don't go to the big expense of preparing applications for something that's going to be challenging to get a patent. So I guess the next step is we kind of know when we should file or we kind of know what we should file patent applications for. But then the next question is, when do you file for patent protection? What's the timing on that? I think our short answer will be just file as soon as possible after it's ready for patenting. The short answer is you want to file it before any public disclosures, before you present at a conference, before you publish a white paper, before you make a sale or offer to sale. You want to file at least a provisional application before that public disclosure. Importantly, because most countries in the world, Europe and a lot of the other ones other than the U.S., have laws that say you need to file the application before the invention is made available to the public. So that's the general rule. File before it's made publicly available. In the U.S., if you happen to have a disclosure that was public, you do have the 1-year grace period. Again, that's only for the U.S. If you have a disclosure, some sale, then you have 1 year to file your patent application. So if you have some disclosure like that, you need to tell your lawyers to start the clock and make sure they file, within that year grace period. And first to file wins. So this again goes to the concept of file early. File as soon as you have the ideas available, as soon as it's become ready for patenting, because the invention goes to the first inventor to file a patent application. It's still important to keep lab notebooks to document your inventions, just to show that you actually are an inventor. And it's important as well, in case you're working with third parties and they're a question of whether your developer stole your idea, for example. For example, in savings example, it's important to know exactly who invented what. So the takeaway is file as soon as possible, but before any public or non-confidential disclosure. Provisional applications. I mentioned those earlier. We like provisional applications because you can get these on file relatively early, relatively inexpensively, because there's no formalities. There's this saying that you could technically write on a napkin and file it for the patent office. We don't recommend that. You do want enough detail that conveys the invention and how to make and use it in sufficient detail, but you don't have any formality requirements. So we recommend filing those as soon as possible. That essentially gives you 1 year, gives you a year to show development of your product before you have to file the non-provisional application or the PCT application, which is essentially an international placeholder. So it gives you that 12 months. If you don't file within the year, you lose your priority claim. And these are usually less expensive than a full non-provisional application. One note here as it relates to trade secrets is, I talked earlier about whether to file for patent or keep it as a trade secret. If you're unsure, it's a good idea to file your provisional application. And then over the course of that year, if you decide, well, no, it's better to keep this confidential, then you can always just let the provisional application lapse and it would never publish if it goes abandoned. So how do you get a patent? Well, you file it with the U.S. Patent and Trademark Office. So here's a timeline of it. Your provisional application is usually the first application you file. You could start with the non-provisional, but the provisionals are usually less expensive, and it usually gets your stake in the ground in terms of your filing date, which is always good. Remember, first to file is important. It's important to file early. So if you don't have anything ready, just file a provisional as soon as you can. That gives you 12 months before you have to convert it to a regular U.S. application or a PCT application. Again, that's an international application. And that's where the costs start to get a little bit more. They're moderate costs in terms of preparing a more detailed document. They're filing fees with the U.S. Patent Office. And if you want, you can consider prioritized examination. Sometimes you may want to get a patent sooner rather than later, in which case you can pay another fee in order to fast track your application. 18 months after your first date, the application publishes, it becomes publicly available. 30 months after your provisional application, foreign filings are due. This is really where the expenses kick in, depending on how many jurisdictions you want to file in. So depending on how many countries you want to file in, if you just want to file in one or two, it may not be that much. But if you want to file across the globe, we're talking easily into the 6 figures in terms of costs for obtaining foreign protection. Now the process is, you're going to file your application. The examiner is going to, you're going to go back and forth with a negotiation with the examiner, and hopefully ultimately you get the patent allowed and then the patent issues. So that's generally how the patent process works. Now hand it over to Jessica, who's going to talk about how do you avoid getting sued.
Okay, so this is a question I get a lot, and the answer is really how do you manage the risk of getting sued? So we normally we look at it from the trademark and the patent perspective. We do searches, we look and see what's out there. So for patent freedom to operate analysis, we would be searching based on patent claims. Now this is looking for third-party patents that could possibly cover your product or your proposed product as well. So I'll go into a little more detail about how we do that analysis in the next few slides with an example, but it will go back to what Paul mentioned, knowing the difference between patentability and infringement. And here we're looking more at infringement. And so I'll go into that in a little more detail in a second. Also, we do the freedom of operate analysis. Typically, we try to do it as early as we can because you'll see some of the things we can do to avoid it or to minimize our risk involve early in the process development. But throughout your development, you want to continue to do monitoring and searches and watches. So this is why I mentioned with say Bing's comment about Neovasc and how they found a Neovasc patent that had published on some technology that his client was working on. A lot of times we will set up monitors and watches for our clients. We'll do this based on keywords. Sometimes you can do it based on a company name. So if you know that there's a competitor in the field that you want to kind of watch what they're doing, this is a good way to do it. You set up a monitor. Also trademark clearance. So again, do it early. I think the biggest problem we see is our clients come to us, they've been using a trademark, it's part of their branding, it's on their product. And we do a search and we realize there's another company that already uses that trademark. And changing it later in the process, it can be done, but it's you lose a lot of that goodwill you built up with the initial launch with the first brand name. So let's go a little bit deeper into the freedom to operate analysis. Let me see if it looks like there's a question real quick before I go into that. Let me see if we're going to go ahead and handle this. The question is there any common mistakes you see founders make when it comes to applying for a patent? I don't know, Sabine or Paul, if you want to handle that question real quick. And then
I'll just give a quick answer. One problem and mistake I see is that relying on the provisional system is only as good as what you put into the provisional application. So as Paul said, if you just filed what's written on a cocktail napkin and you file that and it's not really described well enough, you can become complacent thinking that you've got good protection when you really don't because you didn't file enough in the provisional.
Right. I think your searching helps with that a lot. So that's the patentability searching you're going to do. You're going to see what else is out there and what would be the patentable subject matter. So you want to make sure you have enough in your provisionals to cover all that. So this searching, though, is going to be the freedom to operate searching. Again, we're looking for third-party patents that could possibly cover your claims and cause an infringement risk. And so here I have claim 1 on the left side with 5 elements and the proposed product and how each of the points of the proposed product map to it. As you can see, the first product we're looking at here, there doesn't have a wheel on each leg, therefore you're not infringing. For the dependent claims might have some of the more features that are in your product, but if your independent claim isn't infringing, your dependent claim isn't either. So the next example, though, we'll look at, this is where you come see problems, is you have the same five limitations, a different proposed product, and all 5 of those limitations are in your device. And you may have additional features here, and this is where Paul's talking about patentability. You have additional features that make your claims patentable, but you still could be infringing the third-party patents. You have to keep that consideration. And so the next slide, quickly, I'll go into what do you do if you see a problem patent. So if you see the situation we had on the second example where all the limitations are met from a third-party patent in your product. There are ways we can deal with this. You can work with your IP counsel to work on non-infringement positions that you could have. There are possibilities that the claims maybe don't read exactly on your proposed product because of the scope of the claims. Maybe there's something that limited that scope of the claims, and these are the kind of positions you want to work out with your attorneys and figure out if they will be viable and lower that risk of infringement. Invalidity assessment is another way you can attack that third-party patent. Is that third-party patent valid? Is there other prior art that the patent office didn't find Are there other ways? Is it expired? So again, work with your IP counsel. You want to document these and consider legal opinions to avoid willful infringement in litigation. Other options, design rounds. So early stage, do the freedom to operate search early. If you do it early enough, maybe there's a way you can change your chair so it doesn't have wheels and you don't infringe that patent. Maybe there's a different backrest you can put on that doesn't infringe that limitation. So you can design around and have design around options. And sometimes it's a small tweak, but it gets you outside of the patent and limits that risk. If you can't get around it, you want to talk to your counsel about maybe negotiating a license there. And in the end, sometimes you can't avoid litigation. So again, this is important. Document what your positions may be, consider legal opinions, because you want to avoid a willful infringement charge in litigation. And so this next slide, we'll just go through real quick, kind of where do you start? So we gave you so many ideas, so many things to think about. Where do you start? What are the main key things to focus on? And so I'll go through it real quick because I know we're running out of time, but we want to identify any protectable assets. So that's what Paul was talking about, patents, trademarks, trade secrets, create an IP management process. This, I think, is key. You want to have somebody who knows what's going on with your IP. But it could be an IP committee. It could be, an engineer at some senior level that has a good handle of what is the IP, where are the inventions coming from, do we have disclosures, are there agreements in place? In really early stage companies, really small companies, a lot of times it has to be the C-level people. The CEO has to know what's going on with the IP. They have to know what IP you have, what IP maybe your competitor has, and kind of get a good understanding of that. Again, you can work with your counsel to provide you this information. And confirm IP ownership, that's what Sabine talked about. Remember that one, that's key. We see a lot of problems relating to that. And file patents early, get things, I think that's the theme of this whole presentation, get things done early. File your patents early, know your competition early, do your searching, do your freedom to operate analysis, do your trademark clearances early so that you know what's out there and what to expect. Any other questions we can answer right now? I know I flew through that last slide. And we're running out of time as well, or we're out of time, sorry. So we will all be in the breakout session. So please, if you have any questions, come and see us there. It's called Ask an IP Expert. So we will be able to field any more questions about anything we talked about here or anything else you have questions about relating to IP. And join my colleague Mauricio Uribe in session 2 for his presentation there. I think that's it for us.
Well, thank you all very much. That was fantastic. What a great panel. I really appreciate Knobee, Martens for being here and talking about this stuff. And we just discussed the how of what to do and why to do it for IP. In a little while, right after networking, we're going to start the why. So I want to thank our panel very, very much for joining us. They were fantastic. And we're going to use right in to hop in, which is 15 minutes of one-on-one networking, which, to be very honest, is my very favorite part. So look for us there. And in 15 minutes, we'll be back here doing the next panel. So thank you all very, very much. Hi, everybody. Thanks for coming back. I hope your networking went well. I'm really excited for more of it. I think this is going to be a great panel coming up. We're going to talk about not the what to do with your IP, but the why to do it. Specifically, how to get your IP ready for an investment from an intellectual property focused investor, whether it's a VC, a strategic, or somebody else. So with that, I'll give you Mauricio Uribe from Knobee Martens. Thanks so much.
Good morning, everyone. My name is Mauricio Uribe, partner with Knobee Martens. Certainly happy to be here. Most importantly, I'm happy to be here in Austin. I'm live and hope to see some of you at the happy hour later tonight. We can ask some questions, but I'm joined by 3 fantastic panelists. And today's panel, as Mark had mentioned, it's positioning IP for investors and exits. And hopefully that's a topic that we found a particular interest to this community and to the Austin Startup Week. And so just a quick background, I'm a partner at Knobee Martens. My background's in electrical engineering and computer engineering, and I represent primarily software, telecommunications, and medical device companies. And I've been practicing for almost 25 years. And so I've seen quite a few of the legal side in terms of companies getting investments, companies seeking IPO, or ultimately some acquisitions. And we're going to talk about all of that along the way. And really, the point of this panel is we don't have any slides to present. This is really meant to be a real-time conversation. And I think once you get a full introduction of our panelists, you'll really realize how valuable, and each of our panelists have such a different perspective from the world of funding, from the world of exits. And I think really the goal is here for them to share their real-time experiences or their best practices along the way. And so I'm very happy here. And really what I thought from our perspective is that we'd like for each of the panelists to introduce themselves in their own words in terms of what perspective they'll be providing. And so as they provide different answers to some of our questions, you'll get that sense and that feeling of the context by which the speakers are providing that advice. And so with that, I'm greeted by, I'd like to greet actually, three of our panelists, Dr. Rose Thiessen. She's founder, member of Inventions, and actually a former partner at Knobee Martens. We practiced for many years together. Jeffrey Thatcher, he's chief scientist at Spectral MD, and Troy Hartzell, he's managing partner at Evolution Capital Advisors. And so Rose, if you wouldn't mind, a quick introduction yourself and the experience by which you provide.
Thanks, Mauricio. I'm really excited to be here today and discuss some of the things that have come up in my practice over the years. Like Mauricio said, my name is Rose Thiessen. In addition to my recent startup, Cinefex LLC, which provides consulting services in the area of intellectual property to various clients, I'm also general counsel for Epitracker. They're a nutraceutical and pharmaceutical startup. They're headquartered in San Diego, California. Like Mauricio said, prior to my present positions, I was a partner at Knobee Martens San Diego office. My practice then and now focuses on the life sciences, including pharmaceuticals, nutraceuticals, medical devices, and I also do quite a bit of clean tech and green tech, including solar technologies, wastewater treatment, desalination, and recycling of plastics and rubber. I've also got some industry experience. I did a stint at Exxon Mobil Corporation as fuels formulation chemist. Another little tidbit, I am an angel investor with the San Diego chapter of Tech Coast Angels. Over the years, I've represented pretty much every type of company and individual you can imagine. I've dealt with one-person startups through multinational publicly traded corporations. I've seen folks through the formation stage, through getting the funding, and finally having that glorious exit at the end. So I'm hoping I can share some of my experiences with you, and hopefully you'll gain some learnings that will help you in your own businesses.
Well, I'm sure that, Rose, welcome. Troy, why don't we go with you next, if you wouldn't mind, introduction for our audience.
Sure. Hey, my name is Troy Hartzell. I'm based here in Seattle, Washington, so I appreciate the invitation here. I just got back from a trip to Austin and really enjoyed myself. It's a great town. I've spent the vast majority of my career in early stage technology finance work. I run a boutique investment bank based here in Seattle that's focused on really what we classify as sort of entrepreneurial stage businesses. So, my focus is pretty specialized in truly early stage businesses. Tend to be mostly business-to-business SaaS companies, done a lot of software services, hardware deals over the years, but tend to spend most of my time these days sort of focused on the software side of the house. So that's a bit of where my lens will be coming from. Most of the clients I work with are sub $10 million revenue businesses. A lot of them, like the folks in this audience, are closer to 0 to $1 million. So very familiar with working with companies at a very early stage. And at Evolution, we spend all of our time focused on really two things. One is really helping prepare and execute financing work for our clients, companies that are looking to raise equity rounds. It could range anywhere from $3 to $15 million, sort of that first institutional round of financing. And then we help with companies and exits that tend to be unique in the sense that companies are so much more capital efficient these days. They can stand themselves up with relatively small amounts of capital, sometimes no institutional capital in them, and be faced with situations where strategic buyers want to take them out earlier in the process. So we sort of uniquely service that portion of the market as well too. So I think I'll be able to bring a perspective that is pretty on point for the types of things we'll be talking about as it relates to IP and just general financing and M&A work.
Perfect. Thanks, Troy. And Jeff, certainly last but not least, same thing. Please introduce yourself. Happy to have you.
Yeah, thank you very much. Thanks for having me. My name is Jeffrey Thatcher. I've been working in a startup for quite some time. My role right now is chief scientist at a company called Spectral MD, and we focus on medical devices, more specifically imaging, and we do a lot of kind of deep learning, machine learning, things that are really have been really big in the last 10 years on the data side. So my background is kind of varied. I have a PhD in biomedical engineering, and I kind of jumped from molecular biology to that. So kind of have a wide range of science background. And I started the company as employee number 4. And, my perspective is a little bit more narrow. I'm kind of still in the throes of this startup world. So we've made a lot of progress. I've been through a lot of different changes at the company, and I've been particularly involved in helping build our IP strategy and getting the patent secured to help us operate in our space.
Perfect. Thanks, Jeff. Before we start with the questions I had prepared for our panelists, we do welcome questions from the audience. To the extent we can address them in the real-time flow of our conversation this morning, we'd be happy to do so. And as Jessica, I think for those of you that attended the previous session, feel free to ask questions. If we can't get to them here, we do have the breakout sessions right after this, kind of the fourth component of our morning together. And so maybe we can even answer some of those questions during the breakout session. So please feel free to ask questions or follow up from any of the comments our panelists made. So with that, let's get started. Maybe start with the basics, right? In terms of, when I did some research and looked and said, well, how do you define exits, right? If our panel discussion today is really about exits and mergers, acquisitions, targeted sale, initial public offering, liquidation, that's a standard definition. So to our panelists, I'd first ask it, is that the appropriate definition for exit? Do you have other examples that maybe we should consider? And because today's conversation is about IP, does the IP strategy you have vary based on either of those type of exits? So do you have to have a certain exit in mind and then develop your IP, or does your IP strategy kind of apply equally amongst that? So that's a pretty complex question. Rose, why don't we start with you? I know that's something that you had some thoughts about.
I would say that the type of intellectual property strategy you pursue is more driven by the technology than your ultimate exit. Folks who are doing diligence for funding rounds are pretty much going to be looking at the same thing as the underwriters are going to be looking at when you're talking about an IPO. Same thing with an acquisition. They're going to be kicking the tires on your patent portfolio if you're in a technology space where patents are important. So I would say that I would not be so concerned about trying to match an IP strategy to your potential exit. Oftentimes you don't know exactly what your exit's going to be until you get there. Nobody plans on a liquidation, but unfortunately, over the years, I've had a few clients who have faced that, and you play the hand you're dealt. But I would say focus more on your technology. What are other people in your technology space doing? What is your patent counsel recommending that you do in view of your business goals and your technology, and go with that.
Okay, perfect. Troy, what do you think about that? From your perspective?
Well, I think that's right. I think, regardless of what exit path you ultimately take, I think everyone's going to be looking at very similar things. I think that, companies that are sort of at an earlier stage of their life cycle, there may be different things they want to be thinking about in terms of preparation. So I just think, again, sort of back to the point that I referenced earlier, a lot of these companies have an opportunity to exit at much earlier stages. And so the IP portfolio that they develop may not be as broad. There may not be as much breadth to that. It may be in the very infancy stages of that. But I think, critically just sort of thinking through, what sort of moat can I build? What scaffolding needs to be in place? How should I be thinking about that? Getting good counsel from folks. I think that's all going to be relevant regardless of what exit path you take. So I think one is sort of strategically, how do you think about building that moat? How does that help you out from an operations perspective? But then ultimately just making sure that you've got good sort of corporate hygiene in terms of how you're putting things in place, how you're documenting things, how you're sort of packaging up, ensuring that you've got ownership over that IP. I think all of those things are super relevant things to be thinking about, regardless of the ultimate exit, whether that's via an investment or an acquisition.
Perfect. Thanks, Troy. And for those of you that attended the previous session, that's exactly what my colleague, Sadine Lee, talked about, specifically about those ownership issues and the fact that they can creep up on you, and you don't want it to happen to the diligence side. You want to take it ahead of time. Jeff, you're welcome to comment on that, but I'm also going to tee up the next question for you so you can lead us off into that aspect as well. And one of the things that we've seen in our conversation, over the last 2 years, things have just been quite hectic, crazy. There is a new normal. There is no normal. Companies have to change oftentimes the way they operate. Maybe there's a pivot there. Maybe there's a delay. So from the perspective of developing an IP strategy for the long game, the exit, does that change, even though in the temporary time, you as a company might have to change slightly the focus just to get through some tough times or a change in economy? Do you keep that IP strategy saying, look, our long game is really about a successful exit at some point or reaching a funding? So it's okay to do those pivots in a way, but we're going to keep our IP strategy fairly the same.
Yeah, no, that's a great question. I would make a small comment on the previous question. Is as exits, of course, we all want to have that big payout at the end, but I think we shouldn't, forget that some of these strategies also can be useful stepping stones along the way. For instance, we went and did an IPO recently, and our strategy for that was actually to raise funds. So even though it is typically an exit strategy, it was useful for us for fundraising as we go forward. So, and yeah, we're always thinking about different exit strategies as well. And they made some good comments about where we are and how to think about which ones depending on where you are in the stage of your business. As far as changing IP strategy, yeah, I don't think any startup would be unused to the idea of pivoting, making different, finding different customers, maybe finding different value propositions, maybe changing technology completely. This is something we have to think about a lot, especially if we make a modification to our imaging platform. So we really work with our IP attorneys a lot to help us understand how we can leverage the patents that we have to move on to maybe some changes to that platform. So that's been a big thing going on over the last 10 years of this company is how do we continually leverage patents that we have and also grab new technology into that patent portfolio. So we work with a lot of doing the provisional patent applications and then kind of lining those up one after the other and then setting them all up for a final application about a year later. So working with the patent attorneys to strategize how to make those claims work is really important.
Perfect. Rose, thoughts on that?
Yeah, the past couple of years have been very difficult. Funding's gotten a little bit tighter. I've had some clients who have really had to tighten the belt, and your IP counsel can be invaluable with that. They'll have a good sense for what others in the industry are doing. So if you have to sacrifice maybe some foreign countries in your portfolio, they can advise you on that. If they know money's tight, they can also advise you on ways to defer costs as much as possible. My clients love to file a provisional application as their first filing and then move on to a PCT later on. And then down the road, you can enter the national stage. So, the whole idea is don't spend the money until you have to. And your IP counsel provides invaluable guidance in that regard because, when funds are tight and you've got to make payroll and you've got to keep the lights on, and you've got to keep your portfolio going, you have to make some tough decisions, but you really need some thoughtful guidance when it comes to that.
Troy, I'm going to welcome you to comment on that, but also tee up to you the next question as we bridge over. And it's something that Jeff said I'd like for us to focus on a little bit more in terms of if a company is considered a product company or maybe a service company, or maybe it's both or they're pivoting away, does the characterization of that company impact how that IP role will have for a funding event or an exit along the way? Does it really matter whether you position yourself as one of those, either type of company, or do you have to be open to it?
Mm-hmm. I think, sort of more broadly speaking, it really, I think all of this comes down to how deep is your technology. Like, is the play that you're making a deep science play? I just think there's a lot of really great applications of technology that are out there. There's a lot of sort of traditional sort of scaffolding now that's in place that allows a lot of these companies to get operational really quickly, where sort of IP portfolios maybe are less relevant, not as important to investors, but more about sort of just, again, back to the point of ensuring that you've got clear ownership of whatever you're developing and building. So in deep science, I think it's absolutely critical to build those portfolios out, maybe a little bit less important in the early stages if it's more of an application of technology. I think as it comes down to a services business, again, I think for services businesses where investors or acquirers are focused, is they're looking at where is the domain expertise, what sort of scale do you have in your business, do you have an ability to scale that business efficiently, and looking at maybe different characteristics where there isn't as much of an opportunity to create IP or an IP, sort of a defensible moat around that IP. I think where that starts to blur a little bit is probably when you start thinking more about managed services or technology-enabled services, where you're utilizing some piece of proprietary code or system that you've developed that gives you sort of an unfair competitive advantage out there. And in those situations, there may be ways to protect that through patents or trade secrets or other mechanisms where that may become more important. So I think it's sort of is across the board, but I do think there are different lenses that you put on those different businesses in terms of if you've got a limited amount of capital, where are you spending that? Where are you investing that in the early stages?
Okay, perfect, Troy. Rose, thoughts on that?
I'd have to echo those thoughts. It just seems like you've got to stay flexible and do what you need to do. Yeah.
Perfect. So,
I have a
Jeff, I'm gonna again. I know you'd already commented on that aspect, but certainly tee up for the next one. And I wish I'd come up with this, but I heard a couple years ago that every company is a data factory, no matter what industry they have and what they do. And I absolutely love that analogy, and I use it freely now in terms of that's my go-to teeing up the data rights kind of question. And this is something that you had mentioned that you might have in terms of a company as well, is with regard to amassing data or having data library or expertise. How important is that in terms of IP exits or IP strategies or even funding events when that ends up being a pretty significant asset for a company?
Yeah, that's exactly how we look at it as the asset side. I would imagine that as time has gone by, that's become more and more and more critical, and people starting to see that as an asset because of the ways that we can leverage data that we never thought we could in the past. So that and in our interactions with investors, that was definitely a big factor for our company, was having a data set that was unique, that wasn't easily obtained, say, through open data sets that are available and you can download on the internet today. So it kind of differentiates you from other competitors when you have data that is unique and applies to solving a business problem. And I think it does have immediate value as an asset. And I think it kind of locks other people out of your space in some cases because it takes a lot of time and money to develop those data sets. Especially in our space where we're looking at clinical data, it costs millions of dollars to get images of patients under the right agreements with institutions. So that can take a lot of time, that even if other people have the money, it's just difficult to do that because of the time. And it also gives you, I think data also gives you a resource for just building new features onto a technology. I mean, looking at things like Google Maps, I mean, the amount of features that keep popping up on that is astounding, and it's all because they're able to leverage data. So that's one of the reasons why it's such a good asset. But one of the things that makes it challenging is you've got to think about the other side, which is rights and ownership to the data, like you guys have described with the patents. So coming back to our industry again, in the medical space, individuals have rights to their data. There's HIPAA laws that prevent use of personal medical information. So we have to limit the data that we're allowed to acquire from hospitals. Also, when we're acquiring data from another institution, the institution may have rights to that data. they may be able to limit the rights that you're allowed to use that data for. And then one thing came to mind as we were talking about it yesterday that I didn't mention was there are open data sets available that a lot of people are using to start building machine learning applications and deep learning models. But we have to be careful. Like this came up for us recently that some open source data sets have non-commercial licenses. So we had to run that through our IP attorneys actually. And they, said you got to be very careful. You really need to understand how you might use that data. If you're going to use it to train an algorithm, for instance, and that algorithm then becomes commercial, there may be limitations to that. So it's really good to be upfront because you don't want to get too far along without understanding how much you can actually use the data for.
Yeah, those are great comments. And I think that's actually pretty key, right? Because I think a worst case scenario would be at the time that you're holding that out to be an asset at a funding event or an exit, to find out that the underlying necessary licenses, the commercial license to that code wasn't available, would be a really bad time to have that recognized, or just creates delays. Even if it could be resolved, just creates that unnecessary delay, and all of a sudden something that hopefully would have been a positive ends up being a bit of a wrinkle to that process.
Yeah.
And so I'm going to do a follow-up question, and again for Troy or Rose or both of you, how, what I often see is really kind of two flavors, right? The way Jeff described it is a company in which the data is a key asset, maybe a primary tool. And then all those companies who are maybe product companies, right? And they're just generating and collecting data. And they're like, at some point, I know this is going to be valuable. We haven't quite figured out what our use of this or what our role for the data is going to be, but we're collecting this and eventually we'll find that use. And does that make a difference, right? Is that still as valuable of an asset, or are there certain things as just say, look, if you've been able to connect those dots in terms of how you use data, that's very valuable. If you've just got data there and you still haven't pinpointed it, but you've still amassed it, maybe it's a lesser value or not. I don't know if you have a thought on that. Maybe Troy, we'll start with you.
Yeah, no, I think data is valuable in all of these businesses, and I think especially when it comes to machine learning or natural language processing, where those big corpuses of data are extremely valuable. I think with a lot of software companies that we work with, there's this data exhaust, right, that comes off of just the standard product, and that in itself has the ability to be productized. It can be used for industry benchmarking. It can be used for a whole variety of things that I think enable them to monetize that. I think where we see more emphasis, at least from investors and from acquirers, is sort of to Jeff's point, which is, hey, do you have ownership of this? Who really owns this data? Are you compliant with all the new regulations around privacy and data protection? So how is that data being collected? How is that data being stored? Who's storing it? Where is it stored? Are your user agreements, architected in a way that enables you to have ownership over that data and use it in a commercial way? So, I think it's absolutely valuable. And I think there definitely needs to be a strategy there, working with attorneys to ensure that you can use that in the ways that you want to, and you've got the broadest berth in terms of your ability to sort of apply that.
Okay. Rose, thoughts?
Yeah, sometimes I think it's a little easier if you go into a particular situation knowing that you're generating data that's going to be used for a particular purpose, like FDA clinical trials. You're going to get a data package out of that that's going to be an extremely valuable asset to your company. And so you're going to want to make sure everything's taken care of correctly on that. But in the course of doing research, you're always going to get learnings coming up. And you want to take care to make sure that you're protecting those and you're making sure that you aren't giving away something that turns out to be a valuable intellectual property asset later on. I'm thinking situations where you might be sharing materials with universities and they go off and do some research and find that drug compound you sent to them for some testing turns out to be wonderful for a new indication. And maybe they put the cart before the horse and publish something and you didn't get a chance to file an application on it. And first to file now, you've lost your opportunity. Also, sometimes you can go back and, sift through your data and see some new learning that comes up that might be really interesting and something that you want to pursue later on. So I think you need to be really careful with your data, treat it all like it's incredibly valuable, even if you don't think it is at the time. Give it the proper respect so that later on, if it does turn out you've got some golden nugget in the midst of all that, dirt, you're able to do something with it. Because there's nothing that people who are investing or looking for an acquisition like more than, nice solid IP that doesn't have a wart on it from a potential disclosure that happened in the past that might impair your ability to pursue protection.
Okay. We did get some questions from the audience, and I'm going to incorporate those in. But before we get to those questions, one of the unique things about our panel is we actually cover 3 different time zones, right? We're fairly spread out across the United States. And so that lends itself to the question of what impact, if any, does geography play in terms of IP strategies for funding, for exit strategies? Is there such a thing as a difference across the United States in terms of if you're dealing with East Coast versus Midwest versus West Coast? Is there a difference in terms of companies or acquirers or any kind of deals? Troy, we'll start with you.
Yeah, I don't think domestically necessarily there's probably any real issue there. I think maybe just being thoughtful about the go-to-market and maybe trying to have some foresight in terms of who the potential acquiring might ultimately be. Not that you have to name it, but just have an idea of it. In the sense that you're putting in place protections, that are going to be helpful for you as you take this thing across the borders. If you move it into Europe or you're moving it into Asia, South America, have you done all of the appropriate work to make sure that there's protections there? Because while it may not be imperative for you in terms of what you're trying to do in the near term, longer term, that may be very important as a potential acquirer emerges that sees that requires or sees a lot of value in having the appropriate protections in some of the markets that are probably more important to them and where they've got the most leverage.
Rose, Jeff, any thoughts on that?
I'd have to say in the U.S., I deal with a lot of virtual companies. COVID sort of blew the whole, geographic centric model out of the water. Mm-hmm. Nowadays, you can work from pretty much anywhere, and unless somebody told you, you'd never know where they are. So, within the States, I think it's very agnostic in terms of where you're located. But foreign is still tricky. That can be tricky, and get some good advice.
Yeah. We've got our West Coast perspective and our East Coast perspective. Jeff, bring us home with the Midwest. Any thoughts? Do you agree?
Yeah. So again, from our perspective, from what we experienced with our company, we did an IPO. We IPO'd on the London Stock Exchange. So as you can imagine, those investors over there would be highly interested to know that your patents would be enforceable in other territories. So I think, going back to that and the value, the one thing that kind of even rings back with the question about which different industries, service versus technology is, I was talking with our CEO yesterday, and he mentioned that one thing that the patents were really valuable for in that process were to give external validation for what you're doing. So, research publications, other things that show that your technology actually does what you say it does and that it has some value. Those patents can come a long way. And I think from my basic knowledge of that, having international patents can continue to validate that technology, because other countries might be looking at different languages for different IP rights and things like that. So I think that having a global perspective on patents has helped our company.
That's great. That's a great bit of it's a great comment. And actually, all 3 of you touched on that. So I really like that drew that out from our conversation today. So thank you for that. One thing I'd like to at least get at some of the questions. I'm not sure we'll be able to get to all, but non-practicing entities, the NPE threat for startups. 2-part question here is that really a threat for startups, right? Are NPEs primarily looking towards bigger, more well-funded companies? Is that a risk for startup? And then how is that risk viewed with regard to funding, with regard to exit strategies? Is that just a risk that companies carry, and there's always some risk that you carry, or is that something that's unique in terms of an MP having to have a solution for that? Troy, you're from the funding side, right? From the kind of the investor side, how do you view the NPE as applied to startups?
I'm going to have to be honest. I don't know if I'm totally familiar with what an MPE is.
Okay. The term sometimes called patent troll, right? The companies who are just looking to monetize. I tend not to use that term, but it's okay. You know, the patent troll who tries to, basically sue for money. They're not a product company, and they're really trying to leverage royalties off a company.
Yeah, I suppose. Well, we've had a very large institution here in this region that was executing on that strategy for quite some time, and I just from my perspective in terms of what I was aware of, I didn't see any real focus on smaller businesses. The strategy there really was to go after folks that had the capital to sort of dole out the licensing. But I guess with that being said, really making sure that you do some discovery on your end to make sure that there isn't something out there lurking, because regardless of whether or not they're going to come after you, that's a diligence issue, right? That's a risk to any situation, whether it's, financing or acquisition or just straight up operating this business. I think you want to make sure that you're not infringing on anything that exists out there. But I don't think that the crosshairs are going to be focused on these young businesses. It's definitely going to be on the larger ones. But the minute that you have success, be ready.
For sure. So before I ask both Jeff and Rose kind of the company side perspective of that, I think that's going to be unique. Something Troy just asked that I would encourage you to attend our breakout session. I think that's a perfect question for the breakout session. Each of our attorneys will kind of be there and just saying what Troy just said, doing some of that risk, building on what Jessica, if you attended our previous session, said in terms of managing that risk. I think that's a great question for the breakout session in terms of how do you manage that in terms of searching and identifying risk. And so call it a plug for our breakout session, but it is really something that I think is a great topic for us to follow up with that. Mm-hmm. But for our panel today, Jeff and Rose, what do you think company side? How much do you think about the NP issue? Do you just wait till it comes up? Thoughts?
It's pretty much a non-issue. I haven't seen anything like that in years. What concerns me more are our direct competitors. Maybe they're also startups. Oftentimes you'll have people have a falling out and they go off and form their own company, and then you've got a direct competitor to deal with. So it's a situation where you have dueling IP, and you just have to be aware of what they're doing. Keep a close eye on them. Keep your friends close, your enemies closer, so to speak. Be aware of what they're doing as well as what the broader third-party IP landscape looks like, and just to come up with a plan and be ready to execute your plan when necessary. But I don't think you necessarily need to be extremely proactive when it comes to that sort of thing. You just need to have in your mind what you're going to do if a certain situation arises. The last thing you want to be caught like flat-footed when you're in diligence and the other side asks you, hey, what do you think about this patent? And it's something you've never seen before. That's an awful situation to be in. So be aware of what's out there and be able to answer any questions that might come up about that intellectual property in terms of what you would do if they would try to assert it. You're going to attack its validity, take a license, argue non-infringement. There are all sorts of things you can do, but you've got to have a plan.
Jeff,
yeah, I would second exactly what they were saying. I don't think it's probably that big of a deal at an early stage, but you, again, work with good attorneys to get good patents because that's going to protect you if you do come out of it. And one thing that's interesting from my end, just coincidentally, we happen to have had some investment from people who were considered, I guess, patent trolls. So I have had a lot of conversations with people that do that business, and I think the landscape has changed a lot. It's become a lot more difficult. So you're not going to see them even be able to target a company unless there's a really good payout. But potentially, and when you patent something, you're carving out a piece of territory in a space. So you don't want other people to be operating in your space as a small startup. You might look at your patents flip the other direction and go after other people. I don't know if that's a viable strategy, but I'm sure there's people that operate in that space that would be interested in discussing.
Okay. Perfect. I did promise some best practices war stories at the beginning of our panel. I would do our audience a disjustice if I didn't at least ask that, and hopefully we can get to maybe one other question there. But before we get to the additional questions, let's start with the positive, right? I always like to think positive. And what's been the biggest positive influence that you've seen over time where IP had a key role in a funding event or an exit strategy or something that ended up helping out that? And Troy, maybe we'll start with you. I think you might have had a story for us.
Yeah, sure. I think it really relates to sort of the value of IP. Like, why is it important to invest in it, and how does it ultimately drive value? And we had a client that we worked with that had built a really interesting payments business. They had developed out the technology and were deploying that in North America. They had an opportunity to create a joint venture business over in Europe that was really acting as more of sort of a reseller or a VAR of that technology, and had fabulous success, actually outstripping the success of the North American operation. And so, you know, as an acquirer looking at those two discrete businesses, you have one business that looks more like a VAR or a reseller, which is going to trade at a much lower multiple of revenue. Whereas you have a company that has the software, the IP, the intellectual property that's going to have a much higher multiple of revenue. And so the two companies saw the opportunity to sort of put the peanut butter and the jelly together and to really create a great opportunity. And we're able to sort of merge those two businesses together to benefit from the multiple that was associated, the higher multiple that was associated with the business that owned that intellectual property, but then apply that to a much bigger portion of revenue sort of as a combined entity. And the benefit of that, you know, clearly to the folks, you know, that own that intellectual property, because that was really the key driver in taking what was a really nice business and really accentuating it and really creating a really fabulous exit for all the folks that were involved there. So yeah, so I think, you know, taking the time to build that and to invest in that is super important. Is, you know, that really is sort of where the, you know, sort of investors see value.
Rose, Jeff, any other good stories? Anything else positive that you've either seen or experienced yourself?
No, we had Knobee draft some applications for a client, and the client wanted to offload those and monetize them. They managed to find an acquirer in a related technology area. Fortunately, those applications were drafted broadly enough that we were able to sort of pivot the subject matter and pursue claims that would be valuable to that other company. So I'd say, you know, skill and patent drafting is very important, especially if you're trying to monetize an asset later and you want to have as much flexibility as you can in terms of finding potential acquirers for that asset. It's really easy to draft a very specific application to your commercial embodiment, but to have the vision and foresight to sort of push the boundaries a little and build in some flexibility, you never know when that will pay off down the road. And if you want to monetize an asset and you need some cash coming in, that's wonderful.
Jeff, thoughts?
Yeah, I guess I might take a little bit of a different spin on it from my own personal experience, that coming from an academic, you know, environment, you know, patents we looked at in high regard. It meant that you found something, you identified something that was completely new that nobody had done before, and it was going to be a monumental, you know, advancement for the world, I guess. But my experience since really getting into this patent world is you just got to go out there and try to do this, because if you get the right help from the right people, or especially the right attorneys, they're going to be able to help you get patent protection for what you're doing. And so don't be afraid or think that you have to have some unbelievable idea that, you know, is super disruptive to be able to get these things for your company.
Okay. And doesn't necessarily have to be a negative, but what's the biggest, and again, maybe even more general advice here, what's the one pitfall that you see or hear of companies having when it comes to a funding event or an exit that where IP actually ends up being a disruption to that process or a delay in that process? What's like the one thing that you see the most in these kind of deals? Troy, we'll start with you.
Yeah, I just think rule number one is time kills all deals. So just remember that you want to once you've got that term sheet in hand, whether you're selling your business or you're raising your money, you want to get that deal papered and completed as quickly as possible. And so once that document is executed, it opens up sort of the Pandora's box in terms of getting all the legal due diligence done as a part of that. And I think where I see most of the hiccups, if you will, sort of on the back end of those deals is really mostly around IP assignment, just making sure that inventions, that have been created by employees, those individuals that were sort of key contributors to that technology platform, have signed off on that. And you just, again, back to corporate hygiene, just making sure that those agreements are in place and you're just taking the extra time to make sure that those are done, because you don't want to be in a situation where you have an employee or a contractor or someone that is now the linchpin in you getting your deal done where you're held hostage, and that's not a spot anybody wants to be in. And it can create significant delays. Sometimes it's difficult to chase those folks down and to get those signatures put in place. And it can take what should be a 30-day close to something that's more like a 90-day close. So I think just being thoughtful about those sorts of things is super critical.
Okay, Jeff?
Not at this time. I don't think I've quite hit the experience level to have that kind of experience in the past. So.
Okay. Rose, we've got 2 minutes left. I'll let you close out our question answer part with your thoughts on this.
Oh, ownership issues are critical. That's the one hiccup. When you go into diligence or you're looking for a funding round or an exit, no matter what it is, people are going to look at that first. That's number one on the list. So make sure you've got employee agreements in place, agreements with all your contractors. If you're dealing with universities, make sure you've got a written agreement in place. None of this loosey-goosey informal stuff. Everyone you deal with, have a piece of paper with their signature on it. That includes non-disclosure agreements. Because the last thing you want to do is hit that bump in the road and you have to go chase down a signature. And I've been in a situation where they basically held my client up, and it cost quite a bit of money to get that signature. And if everything would have been done perfectly from the get-go, never would have had that happen. You don't want anything interfering with a smooth completion of the diligence.
Okay, and I think one thing that I find fascinating, and if you attended the previous session, we talked a little bit about that. As much time as we spend on the substantive, as an IP attorney, as much time as we spend on the substance part of quality of the description, quality of the claim, capturing all the aspects, it seems like by far the easiest thing to take care of is just the ownership and the assignments and making sure that's in place first, because that's what starts the whole process. At some point, that substantive examination becomes relevant, but you never get to that point if you can't take care of the ownership issues or the NDA issues along that way. And so hopefully that's, you've seen that theme come out now a couple times this morning in the previous session and this session. So if there is a takeaway from that, I think that's by far just that. And Troy, I love the hygiene aspect of it. You just got to take care of that stuff. It's plain and simple. So with that, Jeff, Troy, Rose, thank you so very much.
Yeah,
so happy to talk with you. I've had such a pleasure preparing for this and having today's conversation. Can't thank you enough. And I hope our audience enjoyed it. I do encourage you to attend the breakout sessions and ask all the follow-up questions that hopefully some of these great comments have elicited. So thanks for joining us today. Really appreciate it. And have a great week, everyone. Enjoy.
Thank you.
Well, thank you all. Wonderful panel. Mauricio, you did a phenomenal job. That was a great panel for everybody. And unfortunately, Rose, I think we've all been there chasing down signatures. So you're 100% right. That is something you definitely want to take care of beforehand if you can. So we're going back into networking sessions right now for the next 15 minutes, and that's going to be followed by our third and final session of the day. We're talking about asking an expert in the IP space. So the breakout sessions will follow the networking sessions, and we'll be right back here at 11:20. So thank you all very much. Appreciate it.